They laughed at my client this morning. So if you want to know what it's like to be a plaintiff's employment lawyer that represents employees in discrimination cases, I'll share with you a quick story of something that happened to me this morning. I attended a scheduling conference for a new arbitration case that's been filed with American Arbitration Association. It's called AAA for short. In attendance was the arbitrator that both sides had picked, and I've dealt with her before, and the lawyer for the employer that we're suing, a international oil and gas company. And it's pretty routine. We went over the schedule of the case and some of the procedural deadlines and rules. But then the arbitrator also asked me to give her a brief summary of what the case is about, and I explained it to her that I represented a client that's suing for age discrimination and retaliation for being terminated after engaging in protected activity. And then the arbitrator then turned to the lawyer for the employer and asked her for the employer's position, and she just laughed. I mean, it was just laugh in your face, and she didn't even answer the question. And I believe the arbitrator also sympathetically kind of chuckled with her. And this would not have happened in court, in a regular courtroom, because there's an audience, there's repercussion, there's accountability. But I believe that in private arbitration, there's no accountability. You could laugh out loud at the other side's case, and the arbitrator will let you get away with it, not even remind counsel of courtroom decorum, because it's not a courtroom, and also try to appear neutral. And you don't have to in arbitration. This is why it's so important that lawyers for employees fight arbitration, because we want to increase our clients' chances of getting a fair trial. And you can't do that in a legal setting where lawyers are allowed to laugh at your case and not even give it the respect that a lawsuit deserves in a court setting. Number two is it also reminds me that, hey, clients sometimes want to embellish and provide minute details in the case. Every time you recite and summarize the case, they kind of push back at it. Well, this setting explains to you why it's not important to mention every little minute detail when you're summarizing the case. And people just hate it when the lawyers summarize the case for them and leave out details that they feel is important. Why? Because context matters. And when the other side is just not going to address each little minute detail, they're just going to laugh at the case in general, well, then you know that it's not important. You got to basically just get past the proceeding, get past the hearing, and then you'll develop the facts later on during the lawsuit/arbitration, and then the laughing then will stop. Okay, back to work.